Hey, beautiful people. So in the past, we went over how the 14th Amendment is functionally non-existent and how it basically is not enforceable by virtue of it not being in existence. We spoke about how each state of so-and-so are retroactively the same as 14th Amendment, which basically is not an enforceable law according to the requirements of the Constitution, which all public servants swear oaths to. Hence, it is what binds them. So if laws are not being created in accordance to what binds them, what limits them, and what grabs them by the balls, and what affords them judicial immunity, then that means that law that you're enforcing cannot be held against anything. And so they can do whatever they want with it. Why? Because it's not in harmony with the thing that binds them, which is the Constitution. That law is not created in accordance to what binds them. So that's the summary of what we've went over regarding 42 U.S.C. 1983, the modern version, and the 14th Amendment when it comes to you bringing claim regarding that. At most, what they're going to do is just drag their feet and bring up other things and ignore you as though you never even have any cause of action, because in truth you did not. Because your supposed cause of action, while you might have actually been injured one way or the other, while you might be entitled to the different types of damages that we've went over in Patreon, the supposition of law that you're bringing in as a foundation to, quote, state a claim upon which relief can be granted is not recognized, and no one is bound to it. No one is bound by it. And if they do not perform on it, they can't be held liable. So that is the clarification and what you ought not to do. So now the question is, well, what do you use? In order for you to know what to use, you must understand two things. You must be savvy to two things. The first is the verbiage within the 14th Amendment itself. And two, the fact that it was retroactive and created after the fact. It was supposedly ratified on July 9th, 1868, and we went over how and why it was not ratified. The other option, that actually is the original solution, was ratified December 15, 1971. Let's read the verbiage of that which is unenforceable and cannot compel performance, and thus you will not be taken serious. The title of it, or at least the summary of it, is regarding citizenship's right. Remember, all of these from Amendment 1, all the amendments are called Bills of Rights. And if they are called bills of right, it's already directly stipulated that these are rights that certain group of people have. And they delineate which specific amendments are categorized as bills of rights. Following are the amendments to the Constitution. The first 10 amendments collectively are commonly known as Bill of Rights. The first 10 amendments are commonly known as Bill of Rights. Commonly, whenever you see this word commonly, you know that they're speaking about general law, aka common law, that everyone always talks about, that everyone always want to invoke. You see how everything is connected. And these substantive rights that's tied to common law only applies to the first 10 amendments, meaning everything afterwards is just a bunch of trash. And guess how they began? They afforded themselves judicial immunity. Judicial immunity that you hear. They began it off with 11. Meaning, anything 11 onward does not apply to the man who intends to invoke a private right of action, which we went over here on YouTube also. the delineation between a private right, public rights, and other type of rights when it comes to stating the claim. In this case, what we're specifically looking at, because if you notice, the First 10th Amendment says nothing about public officials. The articles do, because that's how they were designed. But the amendments were not designed to give or afford public entities and officials, aka persons. The Constitution doesn't say anything about natural or artificial. It just generalizes it as a blanket because this is a commercial instrument. The first 10 says nothing about public officials, but in fact speaks of the people. Literally, it tells you about the people. Anything 11 onward is created retroactively in order to benefit public officials and their entities, president, vice president, judicial power, United States, all that. Now, 14th Amendment, the concept behind it is citizenship's right. The question one ought to ask is, what citizen? Who's citizen? 14th Amendment citizen. This is where the whole concept of 14th Amendment citizen comes in. The First 10th Amendment does not limit it to a specific type of citizenship, or that someone with a specific type of citizenship can enforce the right. If you're a 14th Amendment citizen, it is deemed as slave, and a king or a master is not obligated to the demands and claims of his slave. Hence, it can create supposition and pretense and colorable laws, aka 14th Amendment. So if you're invoking the 14th Amendment, you are saying that you are a 14th Amendment citizen. But if your claim, now that's indirectly, but if your claim is saying you're a sovereign, you're a private man, and you're invoking 14th Amendment, they are looking at you like you are a fool. Let's read it. All persons born or naturalized in the United States. Naturalization is based on 8 U.S.C. That's done with the Attorney General versus the Secretary of State when it comes to declaring non-citizen national of the United States. But nonetheless, whether you're a non-citizen national or you're naturalized, it is still under the jurisdiction of the United States. That is another misconception that a lot of people hold. Even if you are non-citizen national, it is still of United States. Don't get that twisted. You are still under the jurisdiction of the United States. It's just that you're still in that box, but now you're on top rather than the bottom. It's another subject for another day. But the 14th Amendment lets you know automatically that you are dealing with anything based on naturalization. And of course, being born is delineated and referring to the birth certificate. Birth certificate and 14th Amendment are tied together. And these are the verbiage that they use to tie it all together. Very subtle, but very clear nonetheless for those who have eyes to see. All persons born or naturalized in the United States and subject to the jurisdiction thereof. They are letting you know we want to make you our subject. In other words, we are your king and you are our subject. The language and the temperament and the attitude and the personality of the language that you are reading within the supposition of law is what tells you the intent behind it. This thing that we just read, all persons born or naturalized in the United States and subject to the jurisdiction thereof, has a specific attitude to it, has a specific tone to it compared to this. Listen to the tone and the spirit. The right of the people to be secured in the person's housing papers in effect against unreasonable searches and seizure shall not be violated. Shall not be violated. It begins with the right. It mentions the people. It mentions security. It mentions everything that anyone under any circumstances involved in. Effect is anything that you cannot see or anything that you can see that you cannot readily fix on one thing or the other. Your house, shelter, the basic things you need, your paper, your contract, how you pass on inheritance, preservation of records, one way or another. It begins off, the tone itself lets you know its intent. Whereas this, on the other hand, it lets you know by its tone, look, this is what's going on. We're going to put our fists down. All persons born or naturalized in the United States and subject to the jurisdiction thereof, meaning automatically they're telling you, you are our subject. Don't matter if we were established based on our articles that we recently created in 1861, 1861 really, but then finalized in 1871 in Washington, D.C. Don't matter whether you know that or not. Doesn't matter all the other previous contracts like the Constitution or the Confederation or Association, Magna Carta, and all the other treaties, the Ghent Treaty, all the other ones that we've had with other sovereigns here. Don't matter. What we're saying here is what it is, and we're going to push this all the way and create correspondence statutes, and we're going to always push it in your face as a form of direct hypnosis so that you eat it up. And once you eat it up as a supposition of right, we got you. We can do whatever we want with you. Again, all persons born or naturalized in the United States and subject to the jurisdiction thereof. If someone is telling you you have a right, they will automatically box you in one place or the other. Are citizens of the United States and of the state wherein they reside. We already know that a resident is a property, a dead entity, and is legis, aka birth certificate and the county. No state, and that's what they refer to. That's what they refer to when they say "and of the state where they reside." No state, and state is not necessarily state of so and so, even though this is part of the origin of how the state of are homogenized. A state could literally be your declaration of trust and that entity itself. A state could be a piece of paper saying that you've created a trust, no matter what type of trust it is. That also could be a state. No state shall make or enforce any law which shall abridge the privilege or immunities of citizens of the United States. This is supposed to supplement the rights and obligation of contracts. So they're taking other original substantive rights that's been preserved, and now they're making it specific to their power and their jurisdiction. They are now creating a power within a power, whereas the initial power, which is the Constitution, was supposed to limit them. Now they're creating their indenture as an addendum, as a resolution to the initial one, and are creating a box within a box for the purpose of holding a power that was meant to limit them in the first place. No state shall make or enforce any law which shall abridge the privilege or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction equal protection of the laws. This is the first part that a lot of people try to take to the public courts and attempt to state a claim upon which relief can be granted, but they're smacked with a 12b6, and they sit there wondering why, what happened, how, and guess what? To add the salt to that injury of yours, they're not going to explain themselves. They're just going to keep quiet and throw you out and say, leave us alone, go somewhere with all that crap. Don't bother us. We're going to keep making money. And we're happy that you brought this case here and assisted us in fractionalizing the debt system. We'll make some money, we'll cash out, we'll entertain you for a couple of years, couple of months, waste your time, waste your energy, waste your life force, and then kick you out. Hopefully there's more of you that will keep coming so we can rinse and repeat. Simple as that. So this part that speaks about, nor shall any state deprive person life, liberty, or property without due process of law. This has already been preserved by previous substantive, properly ratified law. Search and seizure. And the fifth one, the right of the people to be secured in their persons, houses, papers, and effect against unreasonable searches and seizure. They specified that it cannot be searched or seized in an unreasonable manner. And it's a commandment, like the Ten Commandments. Whenever you see the term shall, it's a mandate. It's mandatory. And they're telling you. And then they even go into details of warrants, how it's issued based on probable cause, and the fact that they're all tied into affidavits that must support everything, which is the oath or affirmation. Affirmation, the root word is the same thing as affirmation, affidavit. And in place of that, you can take an oath. And sometimes your religion or your spiritual belief might not allow you to take oaths. And then the specificity of it. This goes into details and preserves that right. And then the Fifth Amendment lets you know no person shall be compelled in any criminal case to be a witness against himself, self-confession, self-incrimination, nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use. Meaning this is meant to keep you private. And this does in fact invoke a private right of action and keeps you private. And if they do, they have to give you monies, which everybody wants, right? Isn't that the reason why you created fee schedules? And if they don't want to compensate you, then that's a liability on their end. So they won't be a tortfeasor towards you. So all the same verbiage, life, liberty, pursuit of happiness, due process, with specific conditions that invoke your private right of action, is now substituted in a colorable semblance by saying, nor shall any states deprive any person life, liberty, property without due process of law. They took the same exact thing that pre-existed and that gave you the same substantive right, but on a private side. Now they publicized it. And the only way they could have done that is by not making this law. Because had they went through the proper process of making this 14th Amendment law, which we went over, which they didn't, then there will be no need to have this repetitive verbiage, this exact verbiage. So they took the 4th and the 5th Amendment and they remixed it, mixed and matched it into the 14th Amendment, the first clause. And if you ever notice the previous amendments, which is the first, the Bill of Rights, the one that affords you private right of action, the first 10, the clauses that they have are in sentence format. Meaning at any point, the idea, the concept, the principle, and the enforceability cannot be isolated, can in fact be interrelated. But when you look at all the other ones after the 10th Amendment, you see that they actually number it. They begin to number them. See this? When you number things like this in legalese, they're letting you know that there's an isolation of intent. Legalese are written like math. There's an addition, subtraction, division, and multiplication. And the way that the words are structured lets you know that certain intent are added to one way or the other, or separate. And they do that through numbering system. This also lets you know something is off. These principles in supposition of rights are different. So you ask yourself now, okay, I see the problem with the 14th Amendment, or it makes sense on a moralistic level, or based on what the Constitution says, that the 14th Amendment is not right. And the fact that this homogenizes me into a jurisdiction that I would rather not be in. What do I use in its place? Simple, read it. If you read it and compare it to the first 10 one, which they let you know that these are the Bills of Rights. The first 10 amendments collectively are commonly known as the Bill of Rights. The Bill of Rights is what affords the everyday man a private right of action. You will see that what you will use in place of the 14th is everything else, 1st to the 10th. Specifically the 4th and the 5th, dealing with persons, papers, effect, its securities, and the terms and conditions, and the fact that you must be compensated if any of those are deprived. If you're dealing with religious rights, called civil rights, whatever it is, it's the First Amendment. This First Amendment has the right to freedom of information, right to freedom of speech, right to freedom of association, right to freedom of religion, right to freedom of rights and grievance, and so much more. The Congress shall make no law respecting the establishment of religion, the right of religion, or prohibiting the free exercise of the right of religion, or abridging the freedom of speech, freedom of information, or the press, freedom of preserving things by documentation one way or the other, or the right of people to peaceably assemble, freedom of rights, and the petition of government for redress of grievance, freedom of information, which we'll go over in the future. Freedom of Information Act is just a sensitized version of one of the freedom preserved by the First Amendment, which is freedom of information, which is the last clause, and that last clause is titled freedom of speech. So, answer to the question, what do I use in place of 14th Amendment? Everything else, beginning from the 1st to the 10th, more specifically in most situations, the 4th and the 5th Amendment. That's the response. Take care and best of luck.